Welcome back, everyone, for another half hour of 12 News at 4. I'm Tram Mai. The judge overseeing the Georgia election case is denying the DA's request to try all defendants together. And former President Donald Trump and 16 of his co-defendants are getting a later trial date than 2 others. Team 12's Caribe Devine is live in the newsroom with the details. Caribe?
Hi, Tram. A new scheduling order from Judge Scott McAfee says that it's to be determined for now. The order notes that discovery is due by October 6th and motions are due by December 1st. Co-conspirators and attorneys Kenneth Chesbrough and Sidney Powell want a speedier trial, but the judge says that he hopes to swear in the jury for their case by November 5th. The judge also says that he plans to give defendants access to some grand jury transcripts. Transcripts. Tram, I'll send it back to you.
All right, Caribe, thank you. So criminal defense attorney Hector Diaz joins us once again to talk about this case. All right, so what is the strategy behind this to be tried separately for Trump versus a speedy trial?
Well, you know, Trump's lawyers no doubt are looking at this and they recognize there's some complexity here. They can't go in October. And so, you know, we're talking, I think I read somewhere there's 8 terabytes of potential discovery. That's a lot, right? So they're not ready. And you know, I think if the DA was being forthright, she would acknowledge they're not ready to go in October. We're going to see. I mean, there's going to be apparently this trial that goes on with 2 of the defendants. It's going to be interesting to see if that even goes in October.
So is this a big advantage for Trump then?
Absolutely. Today was a victory for Trump. Yes.
All right. So it sounds, though, to me, Hector, that this sounds like a nightmare for prosecutors, witnesses, and victims who would be forced to testify several times on the same set of facts on the same case simultaneously?
Absolutely. Yes, absolutely. And it's something, no doubt, that the DA in this case anticipated. That, you know, you have 19 defendants where one of the defendants happens to be the former president of the United States. There's a lot of complexity here. Right now, you have 2 groups. Those 2 groups are going to splinter into additional groups. And so, you know, I think even this judge anticipates that we could be looking at 3 or 4 different types of groupings that are going to have different trial dates as we progress. So, yes, and no doubt Trump is going to want to be towards the back end so that he gets a chance to see how the evidence plays out.
This sounds like it'll drag on for a very long time.
We're going to be talking about this next year.
Yeah, no kidding. Okay, so I want to talk about the second big national case here. Brian Kohberger, he's accused of killing 4 University of Idaho students last November. If you'll remember, a hearing was held to consider cameras in the courtroom during his murder trial. The defense, though, asked the judge to ban cameras in the courtroom. Prosecutors backed that move, but the families of the victims, they want transparency. They want cameras. I want to know your take of cameras in the courtroom.
You know, I will tell you, I'm all for transparency. You know, we have seen in the criminal justice system, law enforcement are wearing now body cameras for transparency.
Yeah.
We've seen that, you know, where it has benefited not just the prosecutor, but also the defendant as well. It's exonerated people. And so I'm for transparency. I know there's, you know, the concerns here by Kohberger's attorneys that it's going to prejudice somehow the jury pool.
Right.
I don't know that that's credible. I'll be honest with you. And I think that we're going to see, you know, apparently the judge was supposed to rule today. We'll see that, again, my guess here is that the judge is going to allow cameras. The defense attorneys have the ability to question those jurors in a process called voir dire, jury selection. And you can vet out, you know, what have you seen up to this point? What have you reviewed? Have you read anything about this case? You can get those biases out. Now, does that mean that, you know, the defense attorneys are not going to be nervous that as they progress that people are going to get on their phones? Jurors, they're given an admonition, do not get on your phone during, you know, don't look at social media.
Right.
But again,
I mean, how hard is that in this day and age? And we've had so many high profile cases that have been broadcast. You know, there's O.J. Simpson, Casey Anthony, Alex Murdaugh. I mean, how hard is it for jurors not to know what is happening when they're just glued to their cell phones all the time?
You know, it is every defense attorney's, you know, nightmare, really. You know, when you're laying there at night, everybody knows we get on the phone when you can't sleep and you're scrolling through social media. You know, jurors are susceptible to that same potential, you know, issue there. And so
how do you remain unbiased then? It
is something that, you know, again, they're given those admonitions when they leave for the night. Don't look at anything on the internet. Don't look at your social media, you know, and you're given that admonition. They're reminded, you know, it's a process that there has to be a little bit of trust here that you know, they're following the rules. But we'll have to see how this comes out.
Okay. Hector, you've been wonderful. Thank you so much for all your insight. You might as well be co-anchoring with me at this point. All right. Thank you.